In a purchase agreement, the seller will make promises, right, or representations on the conduct of the business prior to closing. Like these were our financials that we provided you. These are what we've done on taxes. These are all the employees. These are the liabilities we're disclosing, so on and so forth. The company's been organized in this state and we have only one class of stock, et cetera, et cetera. The seller is going to make representations to you. So you're buying exactly what you think you're buying, right? If the seller, if something turns out not to be true post-closing, then the seller has breached one of those representations. If you incur losses related to that breach, then those losses are indemnifiable by the seller. So this kind of could like bleed into the conversation about indemnifications as well.
Yeah.
But this is why diligence is so important, right? Because you're going to do diligence. You're going to say, hey, the seller's provided all these tax returns. They've been true. There's nothing else related. There's no other tax liability outstanding besides like what's on these tax returns. Turns out, there was an audit that he didn't disclose, right? Or there was an inquiry from the IRS or the state taxing authority. Post-closing comes up and you get a follow-up on it. And now, there's this outstanding tax liability. Let's say this is a stock sale scenario because the asset sale, it won't necessarily follow. And you owe $5K in accounting expenses, $10K in legal bills, and you got hit with a $20K penalty from the IRS, right? That's $35K of indemnifiable losses. Then now you could go after the seller for, and they're liable for that under the purchase agreement. So that's typically how they work. Sometimes there's different ways to backstop that, right? Because like the default way, right, with nothing else is like you have to like kind of go after the seller directly and hope the seller like pays you 35 grand, which is like not going to often happen or it's not going to be easy to get that from them.
Yeah.
So there's two options that I see most of the time. There's other creative ways to do it, but one is if you're incorporating a seller note in your deal, you offset indemnifiable losses from the seller note. Right off the principal, if it was a $1 million note and they had $100K in indemnifiable losses you incurred, now it's a $900K note, right? And you'll just re-amortize it over the life of the note. That's the easy one because you could kind of just offset it unilaterally, right? You put that language in the purchase agreement and the seller note that says like, hey, this is, all indemnifiable losses are also, offsettable from the note. The other option, which is better, but sellers on smaller deals are less amenable to this. On bigger deals, it's pretty like common and, almost table stakes. But if you have a separate escrow, right, like an indemnification escrow where it's like, hey, we're holding back $50K of the purchase price and we'll hold it in an escrow for 2 years or 15 months or whatever it may be. But now I actually have a bucket of cash that I can dip my hand into to pay these indemnifiable losses, right? So if I have to pay 20K in IRS penalties for a tax rep being breached, I have a bucket of 20K that basically is set aside from the purchase price that I could go into. That's obviously ideal, right? Because a seller note's not really putting cash in your pocket. It's just like your debt service is being reduced.
Right.
So obviously I push for both in most of my deals. Like I would like a small escrow and then, then a seller note offset after that. So I would say that's ideal, but obviously sometimes it takes some, massaging.